An insurance agent generally has a duty to a client to exercise the care and skill that a reasonably prudent insurance professional would exercise under like circumstances in procuring coverage. But can an agent owe a duty to a client beyond this general duty? The Iowa Supreme Court considered this question in Langwith versus American National General Insurance Company. Janet Fitzgerald was an insurance agent for the American National General Insurance Company. Husband and wife Dennis and Susan Langwith purchased nearly all their insurance through Fitzgerald, including their auto insurance. With regards to their auto insurance, the Langwiths carried a $250,000 liability insurance policy and a $3 million umbrella policy. Both policies covered the Langwiths' 2 children, which included Ben. In December of 2003, Ben's driver's license was suspended, and American canceled Ben's liability coverage. American also sought to cancel the Langwiths' umbrella policy, but they avoided cancellation by signing a form agreeing to a driver exclusion for Ben. After Ben's license was reinstated, Susan met with Fitzgerald and asked for her advice on how to get Ben covered. Fitzgerald then procured a high-risk policy that covered Ben when driving the Langwiths' vehicles. The Langwiths assumed that Ben was also covered by the umbrella policy again. However, there was still a driver exclusion for Ben on that policy. In July of 2006, Ben was involved in an accident while driving a vehicle registered in Dennis's name. A passenger in Ben's vehicle was injured and sued Ben for damages based on negligence. American acknowledged coverage for the claims under the liability policy, but denied coverage under the umbrella policy. Subsequently, Dennis and Ben sued American and Fitzgerald in state district court for negligence. Specifically, they argued that Fitzgerald breached a duty by 1. Failing to disclose that the driver exclusion in the umbrella policy for Ben still existed, and 2. Failing to advise that Dennis could avoid liability for Ben's driving by transferring the vehicle's title to Ben. Following discovery, Fitzgerald moved for summary judgment, which the court granted. Dennis and Ben appealed to the Iowa Supreme Court.